Okay, we'll let a few people get in here before we start talking.
Okay.
Actually, most of the people will watch the replay, so we can start talking. Okay, so we just left Guyman. We're getting close-ish to Four Corners, heading back to Elkhart. All five defendants in the courtroom again today, and it seemed like today they were trying to just basically establish whether or not they're going to consolidate all of the cases. Just explain that. Just the preliminary hearing, are they talking right now? Not the whole trial, right?
Right. So far, they were talking about the preliminary hearing, and the first attorney, which was Cole's attorney, had no objection to consolidating it, but all the rest of the attorneys then, as their turns came up, all objected to consolidating. And basically it had to do with discovery as much as anything. What they were saying is, we've still not gotten information from the prosecution, although I noticed all of them gave hard drives to the prosecution today so that the state can put that discovery on those hard drives. And, last time they were talking about 4 terabytes of information. This time they were talking more like 2 terabytes. But the DA did say, basically, that most of that is video.
Yeah, he said a lot of it was video of the vehicles. We're taking at night, and
right.
So I edit our video here at Back Home Media, and I can tell you, like 20 minutes of raw footage could be anywhere from 15 to 30 gigabytes of information. So 2 terabytes sounds big. It sounded big and scary to me before the DA basically said, there's a lot of information, but the majority of it is just very long videos that are basically what he said are going to be kind of inconsequential to counsel.
Yeah.
Because they're not going to be able to pull a lot of questions out of just them circling the vehicle.
The root of the objection for most of those attorneys was, because we haven't gotten this information yet, we have no idea how long it's going to take us to go through it. So they were objecting to 2 things. Number one, consolidating the preliminary hearings, and 2, setting a date for the preliminary hearings, because the court was wanting to set a date in the middle of December, the 17th, 18th, and 19th of December. So that was the main thing, is different attorneys think it may take them different time to prepare their cases. And so they were objecting to 2 things, basically, and that was consolidation of the cases and setting a date for the preliminary hearing. Cole's attorney was all for it. As a matter of fact, she basically asked that they set a date for the preliminary hearing, but the rest of the attorneys all had objections to it. And all of them basically said that was based on discovery. And so when they meet again in August, and they've received their discovery by then, those objections may go away. I don't know.
As far as just watching the courtroom, Cole seemed to be, I reported last month that his attorney had rubbed his head. They have a secondary attorney there with them between Cole and his attorney, but Norm, correct me if I'm wrong, they had a human being between them. The only thing I can think of is that Cole knows his attorney. They are very, very
they seem to be very familiar with each other, and very friendly with each other, very animated in the way they communicate with each other.
And if they know each other, if they've known each other for a long time, then her rubbing his head last month isn't that big of a deal. But if they just met because of this, and last month she's rubbing his head, and this month they're talking like lost cousins, that's one thing I just noticed. And me and Jessica was in court with us today. We also noticed that Cora, Tiffany, and Cole were all not hysterically or for long periods of time, but they all did say that they would, they all did laugh. Sorry, I'm getting text messages. All of them did laugh throughout, before the judge entered the room. And I will say this is Norm's first time at this case. This is the first time coming with me. Everything, they were in there early, so we showed up 30 minutes early and the defendants were already inside, which has not been the case at all in the past. And then they let us in, and I don't know what time they ended up shutting the door. We didn't have our phones, but it seemed like, I know News Nation wasn't in there. It didn't seem like hardly any reporters were in there except for us and maybe a local publication, which Tad's attorney came and talked to that that news reporter several times. I don't know why. But basically, everything started early, which means the doors got shut in the front of the building and to the courtroom early, I feel like. And so that was a little different. Also, we'll get into this, but the judge, that was what he was there for. He asked everybody. Norm kind of explained that. What he kind of said is he's going to keep those dates that Norm listed open because he and the state of Oklahoma want to try this as soon as possible. So they're going to kind of shoot for that December date. But he did say that he's not going to force anybody to, pull everything together. That being said, that was just the very beginning of the court case of today's hearing, and there's not a lot of information coming out because obviously the defense attorneys don't even have information yet. But Norm was going to talk now because he's more educated than I. We got to see 2 judges today, and again, this is 5 defendants in a capital murder trial. Things went awry today, but again, there's a lot going on. Texas County is doing an amazing job, but one judge handled that, and then he excused himself, and then Norm will take over. Another judge came in and actually heard on some appeals that were made.
Yeah, so Judge Parsley then came in and he heard a motion that again dealt with discovery, but it dealt with discovery that's different for each of the defendants. Okay, so this dealt with court cases from Cimarron County that dealt with both Cora Twombly and Tiffany Adams. And basically, the judge had ordered that those cases in Cimarron County be sealed, but what the judge had not anticipated was that when he sealed the cases, they were sealed from the defense as well. And so the defense's motion was, listen, we get that you want to seal these cases to protect minors and that are mentioned in the cases and all that, but the defense needs to have access to these transcripts and have access to these cases. And so basically they worked it out. The DA, though, he made the point that, listen, here's the statute. If we just follow the statute, we don't have any problem, The problem is that we tried to write some wording in there that wasn't in the statute. But eventually they came to an agreement, and one of the defense attorneys, Mr. Hoke, agreed to write up the language of the actual motion. But they all agreed to it in principle. He'll just write up the language and submit it in the next 10 days. But basically, the decision they came to was, like the judge said, he wants everybody to have access to everything they need. And so basically they came up with that the records would be unsealed for the defense, but that
also sealed to the defense only, basically.
Well, yeah, but they would remain sealed, especially anything that dealt with minors.
Yeah.
Which
I think on the first video I made, no, I think it was the last one. I don't think I was being rude, but usually when I hear public defender, that means it's free, and anything free
it is. Yeah.
So to me, if somebody said, "Do you want a free attorney?" I would just be like, "Yikes, no." Two things. All of it. I want to get to a point, but I don't know why it matters to me, but all 5 defendants, 3 of them are wearing all orange jumpers, and they look fine. But Tad and Cole are wearing those mixtures of white and
they're wearing striped.
Yeah, they're wearing striped, and the colors on them are so faded, and it just looks ratty. And again, I was telling Jessica, I was like, if I was Tad and Cole's attorney, I would demand that they only go to court. Because again, this stuff matters. People, if I'm somebody who's a nobody in the crowd.
Wait. They're wearing handcuffs and shackles.
I understand.
You think that the color of their cups?
I'm telling you. As far as I go, every time I see those 2 and those, my I can't help it. Like the snob in me judges them. Like, ew,
Right.
you look dirty. So like, I'm just saying, like, if I was their attorney, like that's something I would be like, hey, can we just get them in something that doesn't look like it's filthy? But anyway,
The reason I bring that up is normally when they bring defendants into the courtroom, they take the handcuffs and shackles off of them when there's a jury there, right?
Yeah.
Because it makes them look guilty in the eyes of the jury, right? That's why I was saying you're worried about wearing about the color that they're wearing when they're wearing handcuffs and shackles.
Oh, one other thing I'll say is apparently in Texas County they have their own. Did you notice all the defendants are wearing like some form of like knockoff orange Crocs?
Oh no, I didn't notice that.
I told Jessica, I was like, write down jail Crocs. I was like, they're all wearing.
I'm sure they do provide them though, with footwear. So yeah.
But to finish my point, like at first I was kind of like, these poor guys, they have these like public defenders, and I think I even like said like I was worried about them. But the what's the youngest guy's name? Paul's attorney. I feel like when all of them spoke on trying to figure out a way to solve that issue, the second issue with the keeping, basically unsealing it enough for the defense to learn everything, but also keeping it sealed where the public doesn't know it. I felt like he had the most well thought out like idea, and so he really impressed me with that. I was like, wow, this guy's thinking, and then he also suggested to write it for him, and nobody disagreed except for the prosecutor, which basically was just like, let's just do what the law says, like we don't need to write a new thing. Let's just do what the law says.
Yeah, I agree with that, and I also kind of agree with the prosecutor. Yeah, here's the statute. Let's follow the statute.
Yeah. I felt like Tiffany's lawyer. I think he's a good attorney. Like he seems like he's trying really hard. Like that's all I'll say. I if I was trying to get somebody, if I was like, if I had skin in the game and it was like my family, I would be nervous about an attorney that's paying that much attention. But the judge kind of blatantly asked him, like, you filed this so that these transcripts would be sealed, and are you wanting them sealed? Kind of explain what the judge was hinting at, because I guess like that there in some reality there is a way that Tiffany would be not wanting those people to have.
Yeah, okay, but that's not actually what happened. He filed a motion or an objection to the sealing of the records.
Oh, okay.
And he was objecting to the sealing of the records not because he didn't think that they should be sealed, but because they had been sealed from the defense as well. Okay. And so he was objecting to sealing them with that stipulation, saying basically, hey, this is something that should be part of discovery, because it's potential evidence here, and we need to have access to this. Said I understand that needs to be, also weighed with the need to protect minors potentially who are mentioned in these documents. But and so that's what it came down to. Yeah.
And I don't know. So like I agree. As the public, I want to read all of it. And, okay, speak to this though. I know the judge was not saying he wants the world to have it, but he said multiple times, look, it's basically my objective that everybody knows everything. So kind of speak on what he was saying, because that's not what he
that's what he said was, I want everyone to have everything they need.
Yeah.
He was talking about the attorneys, not everyone in general.
Right.
Yeah, that's all he was saying. He was saying, I want all of the legal teams to have everything that they need. Basically, he's saying, I want everyone here to have a fair trial, and so I want everyone to have everything that they need. But somebody give me some language we can write in here so that, we make sure that that's what happens. And like I said,
was found. That's crazy. Go ahead.
So a couple of the defense attorneys suggested some language, but I was kind of with the DA that said, listen, here's the statute. Yeah. If we follow the statute, we're okay, Yeah. And by the way, this is all from cases that have been filed in Cimarron County,
which would be Bush City, right? Like that area. Okay, yeah.
Absolutely, yeah.
And so I was kind of talking to you and Jessica on the way out. Like, I don't think they should be.
The information was already out there,
Yeah.
To me, trying to seal these records is kind of like trying to put the genie back in the bottle.
Yeah.
I mean, people were posting these transcripts, and not all of the transcripts that they were talking about, though, because they made reference to a couple that the transcripts hadn't been completed yet. So not all of what we're talking about today, but much of what we're talking about today was, people were posting it on the internet, before the arrests were made, and so it's stuff that people have seen, but. And yeah, to me, sealing it now is a little bit like trying to put the genie back in the bottle, but not all of it, I guess, has been released. So,
yeah. Well, that's pretty much it, right? Is there anything else you can think of that happened?
That's pretty much it. On August 21st, there will be another hearing, and they'll discuss the objections to consolidation. And they will discuss the objections to setting a preliminary hearing date. And that should come after the defense attorneys have received the discovery from the DA.
The DA did kind of, the way he talked, it seemed like by the 21st, he felt like they would have plenty of time to go through some stuff.
One other thing that they did talk about was, at the last hearing, the defense had made clear that they wanted to have access to materials that were going to be tested for DNA.
Oh, yeah.
And the DA did tell them that there were 3 items to be tested for DNA that the test would consume the item.
Explain that.
Okay, so probably what they're talking about here, okay, and I don't know, I'm just, making an assumption here. Probably what they're talking about is a blood sample, right? Where there's not enough of, it's not a big enough sample that everybody can get a little bit of it. It's just a little drop of blood they found somewhere that they want to test for DNA, and testing it for DNA is going to use up the whole sample. Okay, even if that's not what it is, that would be an example of what they're talking about, right? Let's say you've got, a drop of blood on the dashboard of a car, and you want to test it for DNA. Well, when you take the swab, you're going to use up that whole drop of blood, So that's what they're talking about. And so supposedly there are only three items to be tested for DNA where the DNA test will consume the item. So other than those 3 things, the defense will get their opportunity to perform testing of their own, apparently.
And I noticed that the defense attorneys didn't have a chance to really say anything when he announced that. Is that because they have to file a motion and then it has to go through?
Well, actually, that was already discussed at the last hearing, if I remember right. And basically what they agreed was that anything that didn't fall under that category where the entire sample would be consumed, then the defense would have access to those samples for DNA testing. But on those where the entire thing would be consumed, then they were just going to have to take the state's findings on that and not be able to conduct their own testing on it.
Yeah. All right, I think that is it. All right, everybody. We'll try to keep you posted.